Thank you all for joining us. Thank you for spending lunch with us. My name is Antonio Ginata. I'm the policy director here at Columbia Legal Services. This is my ninth legislative session as policy director. And my goal is to talk about the session and to introduce you also to our panelists who will also be speaking about legislation they worked on today for CLS. Um, so next slide, please. General agenda, I want to talk about this fast and intense legislative session. I'll be talking general overview of the session, and then we'll have the advocate reports on these three particular bills, the Immigrant Worker Protection Act, bill establishing collective bargaining for farm workers, and vehicle shelter protections. And then at the end, um, please do submit questions. There's a Q&A button on Zoom. You can submit questions, and we'll leave a little time at the end to try to answer them. That's the plan. All right. Let's move on. Next slide, please. Um, all right. So this was a 60-day session, the second year in a biennium. But even though session officially starts on the second Monday of the year, this session and the tone and the tenor of this session was established much earlier. So as you see from some of the headlines, back in November, there was already a clear mandate from legislators that this was going to be a deficit year, that new programs were not going to be funded, um, and that there were going to have to be cuts. Um, a journalist actually got their hands on an email sent by the Senate Ways and Means chair, June Robinson, and that was an email to other senators that said, "I will not be soliciting or accepting any member requests for the operating budget in the upcoming session. Please help set expectations around this with your constituents." She was asked about the size of the looming deficit, and she said, "It's really bad. It's billions, and we're going to require cuts." Next slide. All the signs were pointing to a budget deficit year, and a budget deficit, and how that was going to shape session. So that meant many of our priority bills that we had worked on in the past over some for several years, were surely not going to move this year. This signaled, particularly for four bills that we're flagging here, that needed to make a decision that we were not going to move forward on pushing those bills in the legislature this year. One involved creating a wage replacement system, an unemployment type system for immigrant workers, for undocumented immigrant workers. One was about finally ending the coerced labor in prisons. One made prison phone calls free, and another created a jail oversight system. In all four of these cases, it was either a decision of the sponsor or of the advocates supporting the bill that these bills were not going to move this year and needed to take a year off, considering what we were expecting for this session. So next slide, we focused on bills that had the capacity to be passed. And like every other session, we also still had to fight off bad bills. So we supported the bills that we could, and we fought off some bad bills. I wanted to just talk about a couple of the ones that we saw this last session. There was a bill that would create new sentencing enhancements uh, for retail organized theft. We opposed that bill. There was one that created some really unworkable residency requirements for accessing hospital charity care, that would have been um, made access to hospital charity care more difficult for immigrant communities. had to fight against that one. There was one that rolled back some really good progress we had made on reducing legal financial obligations. And there was one tort reform that was trying to make it more difficult to sue the state for harms uh, created by the state. All four of these bills we opposed, and none of them made it through to the end of session. So we were successful there. Next slide, please. We also wanted to add our voice to the push for progressive revenue in the state of Washington. As a civil legal aid organization, our clients are on the lower end of the income spectrum, but they still pay a disproportionate amount of whatever income they have in taxes. In Washington, people with wealth pay a smaller share of their income compared to poor people. So we at CLS helped to partner with 15 other civil legal aid organizations to write a letter to the leadership to express support for progressive revenue and measures like the millionaire tax. We've never done this before, and I really want to thank our partners in the Alliance for Equal Justice who supported this push. And as we've seen, the millionaire tax has passed the legislature and is waiting for signature from the governor, who has signaled that he will sign it. The quote here in the slide is from the letter that we sent to legislative leaders. Okay. Next slide, please. Let's move on to advocate reports. I do want to, I'll take a couple of the first issues and then hand it off to my colleagues. All right, next slide. Apple Health expansion. So Apple Health expansion, if you are not familiar, this is very much a Medicaid-like system that we, as part of the Health Equity for Immigrants campaign from 2 biennia ago, helped to establish. We helped to put it in place. The campaign helped to put it in place, and we were part of that campaign. But they were both. This program has been very much at risk since it was implemented. It was incredibly popular, so much so that the enrollment was filled in the first day with when the doors were open to access Apple Health expansion. This is Medicaid-like, but for people who cannot access Medicaid because of their immigration status. Because it is a budget proviso, it was always at risk for being cut. And the governor, in his proposed budget, did suggest paring back the program in terms of money in the program, and also paring back the services provided. So if I remember correctly from the governor's budget, it was only focused on primary care, behavioral health care, and prescription costs, which is very limited compared to what a Medicaid-like system would be. So we did see the budget cuts. There's about an $11 million cut in the final budget for Apple Health expansion, and it moved from managed care to fee for service. So fee for service is a way to access the coverage where payments are less to providers, where fewer people have access to providers, particularly in rural communities. So those are two steps back, but we were able to maintain a Medicaid-like coverage, so not the limited services proposed by the governor, but similar to Medicaid in the program, and the program will open up to 5,000 new enrollees. I don't remember the exact date, but that's the way the budget. That's the way the budget was finalized. Two steps back, but one step at least forward from the restrictions proposed by the governor. So worked on that. I want to talk about House Bill 2464 as well. Next slide. Representative Ortiz Self came to us to ask, because of our work on immigration detention and private detention writ large over the last few years, to work on a different bill requiring private detention facilities to report critical incidents like a death, a sexual assault, um, to report those to local police. We have heard from our partners at La Resistencia that there were offenses, violations happening that were not being reported to local law enforcement. So we helped to draft this particular bill, House Bill 2464, which made it quickly through the House in this session, and then unfortunately died right at the end of the Senate floor cutoff. It never got heard on the Senate floor. Why did it not get heard? There's lots of theories. We don't think it was a policy disagreement from the Senate. We actually just believe that there was no time. There were a number of bills that died, good bills that died on the Senate floor at the end of session. Like I said, a 60-day session, the turnarounds are very quick. This was the first year for this bill. We're feeling confident that it will pass. It just didn't make it this particular year. With that, let's go to the next slide. This is the House Bill 2105, and I'm going to hand it over to my colleague, Mark Bowers.
Good afternoon, everybody. Thanks, Antonio. My name's Mark Bowers. I'm a staff attorney at the Olympia office for Columbia Legal Services. We started talking internally about the need for a I-9 reporting bill, which is what HB 2105 and its Senate companion SB 5852, I think, became after investigating a workplace raid last year up in Bellingham, and serendipitously at the end of summer, the Attorney General's office reached out to Antonio with questions on technical matters around what a bill like this would look like, because AG Brown had decided that his office wanted to move this type of bill forward. We were very excited to jump in and help out with advising them on technical matters and potential impacts from the perspective of workers in that process. This kind of bill or this kind of laws, it's important. It strengthens protections for workers, for immigrant workers, and it creates kind of a standard of how employers can respond to agencies inspecting their employee records. And it mattered to us because after seeing the destabilization of what happens in these big workplace raids, creating a bill like this gives predictable and upfront notice of when something might be happening, when a government agency might be looking at folks' employment authorization. And for anybody who doesn't know, an I-9 is the form we all fill out when we begin working a job that proves our identity and shows that we have permission or authorization to work in the United States. So this bill moved through both the House and the Senate fairly easily, along partisan lines. Business and the rights pushback had a lot to do with the enforcement mechanisms that were added to it, particularly the value of penalties that the Attorney General could seek and employees' private right of action. Both survived to an extent. There were some compromises that I'll talk about in just a second. So what this bill does, or what this law will be doing, is creating a right of notice. So anytime an employer is notified by a government agency, particularly Department of Homeland Security, Immigration Customs Enforcement, that they'll be inspecting their I-9 records. The employer has 5 business days to notify their employees of the inspection, including a copy of the notice and the dates and information about a statewide organization that provides information and advocacy related to immigrant and refugee rights. The Attorney General's office is going to produce posters in 5 languages that all employers have to post in their business, as well as a model for the notice that there's to send out if they do get an I-9 inspection. It prohibits retaliation or adverse actions taken against any employee that asserts their rights. And then the two important aspects of this is there's enforcement authority for the Attorney General's office, including full investigatory and subpoena power, ability to resolve issues through conciliation, and then take legal action with a potential penalty of $500 per violation. And then for us, what's most important is we preserved a private right of action, which means if a worker doesn't get notice or if they suffer retaliation, they can go to the court themselves and seek injunctive relief, actual damages, and statutory damage up to 40 hours of the current minimum wage, which then so that pegs the penalty to inflation as the wages go up. So there were several compromises made in this to get it through and out of Ways and Means in the Senate. AG's office had been really communicative with us as pushback and challenges came up through this whole process. Unfortunately, this last striker that was filed in Ways and Means to get it out of there, we didn't have a chance to offer any comment on, and it was some of the roughest compromises to the bill. The originally bill was pushing for 72-hour notice because that's how much notice employers get from government officials, and that was extended to 5 business days. There was a reduction in the penalties that the Attorney General's office could seek. There was a reduction in the statutory damages and the private right of action from 80 hours to 40 hours. And then I think the most harmful compromise is they added a section of judicial discretion about the amount of statutory damages, and it creates a kind of weird contradiction within the law that's going to have to be unraveled once this is enacted. So that's what I have. And I think we have another advocate to go to the next bill.
Before we go, I just wanted to thank Mark. This wasn't easy to get this bill across. The amount of pressure from the business lobby was intense and throughout the process. And typically, bills do not end where they start. But to get this one across in the shape that it did come across was particularly what took a lot of effort by a lot of players. So thank you, Mark. Thanks for that. Let's push this to, I think, the next slide, 6045, and Andrea Schmidt.
Hi there. My name's Andrea Schmidt, and I'm a staff attorney also in the Olympia office. All of us, actually, who are presenting today are sitting together in the Olympia office. No surprise. I'm going to talk about the Farm Worker Collective Bargaining Bill, which was Senate Bill 6045 and House Bill 2409. The purpose of the bill was to provide a statutory structure for union elections and for bargaining union contracts for farm workers. And you may ask, why is this necessary? Those are things that everybody has. Agricultural workers, unlike nearly every other kind of worker in this state, do not have the right to hold a union election and have their union recognized as the bargaining representative. Many folks who even know a lot about employment law don't know that fact because it is so strange. Why is there this gap in the law? Well, it goes back a long ways. The National Labor Relations Act, which was passed in 1935, is the main collective bargaining law in the country, and it controls with regard to almost all private sector workers. Farm workers were exempted from the National Labor Relations Act because President Roosevelt needed the votes of the Southern Democrats to pass all of his programs in the New Deal. And the Southern Democrats didn't want these laws to apply to Black people. They couldn't exempt Black people, because of course that wasn't constitutional, so that trick they used was to exempt agricultural workers and domestic workers, which were most of the Black workers in the South at the time. And so agricultural workers were left out of the National Labor Relations Act, and domestic workers were left out of the National Labor Relations Act, out of the Fair Labor Standards Act, out of the Social Security Act, even at the beginning, just to name a few programs that they were exempted from. So we are still living with the effects of this systemic racism in Washington and in many other parts of the country to this day. So why now in Washington did we decide to try to fix this problem? Well, CLS supported the independent farm worker union Familias Unidas por la Justicia when it came into existence in 2013. And that union eventually got a collective bargaining agreement with Sakuma Brothers Farms. But it couldn't do that until after it had a 3-year battle that included strikes and pickets and an international boycott, multiple trips to state court. It was a miracle that Familias came into existence at all and got that collective bargaining agreement because these workers did not have the right to call for a union election. They had to use economic pressure for years until the employer just finally agreed to a private agreement for a union election. And so for a couple of years, Familias had been, its leadership had been discussing how a collective bargaining law could look, with the caveat that it should also preserve the protections for farm worker organizing that do exist, and that they used to form their union in the first place. There are some protections, like the protection against retaliation for trying to form a union, for example. And this year was Senator Saldana, who was our sponsor. It was her last year in the Senate. She has announced that she's going to leave the legislature and run for King County Council. And she was very motivated to help with this bill this year. So what happened? Well, it didn't pass. It was a very hard fight and lots of work by a lot of people. It made it through the Labor Committee and the Fiscal Committee in the Senate, thanks to the work of Senator Saldana, the State Labor Council, and Familias Unidas members who came in person to testify and gave dozens of hours to the effort during the session. It did not make it to a vote on the Senate floor, and we don't know precisely why, but there are rumors that there were a few squeamish moderate Democrats who were not prepared to vote for it, and that there may have been some horse trading related to the millionaire's tax, which was a very large priority for Democrats. So the question is, would we run it again? And we don't know the answer to that, at least not in the short term, because first of all, it depends on what the farm workers think, and we haven't evaluated that for this next session. But we would also need a very strong and informed sponsor. And those are hard to come by on this particular issue. We were very fortunate to have Senator Saldana. And so we will we'll look to the future and see whether it seems feasible to run a bill like this again.
Thank you, Andrea. Next slide, Sarah.
Hi, everybody. I'm Sarah Nagy, also in the Olympia office, here to talk to you about House Bill 1240, championed by Representative Peterson. This is the third year we're running this bill. A little context. So back in 2021, the Washington Supreme Court decided the case of City of Seattle versus Long, which involved a man whose only shelter was his pickup truck. It broke down, it got impounded, and he couldn't pay the fines and fees to get it out. He went to court represented by CLS and our co-counsel Jim Lobsons, and the Supreme Court said, When municipal and district courts set impound fines and fees, the Constitution requires them to take into account people's ability to pay. So that's great. It's in the law now. Courts have to do that, but it's not yet in the statute. So the RCW conflicts with the case law, and that's proven to be really confusing for judges and lawyers and tow operators. On top of that, there are still barriers that keep people who live in their vehicles from getting into the courts and asserting their rights. So even though they have this right, we still need to help give them the tools to access it. And that's what this bill does. It brings the statute in line with the case law. It requires courts to consider the ability to pay before levying towing fees, and it reduces fees if they're excessive. It protects vehicles from being sold at auction if it's somebody's only shelter. And it updates the court processes in a few important ways to make it quicker and easier for people who live in their vehicles to resolve those legal issues and get their homes back. It's been a hard road for this bill. It didn't get a hearing this year. It died at the first deadline. Couple of reasons for that. First, we've put a lot of effort into trying to negotiate with the many stakeholders who are part of this bill. A big one is the tow operators themselves, and they remain steadfastly opposed. They would like to see financial compensation when fines and fees are reduced. And even if we have no objection to that, it's a very difficult biennium to ask for new funding for anything. Second, it's in the House Transportation Committee, which is frankly not a great fit. It's there because that's where bills related to the towing statutes tend to go, but it's fundamentally a bill that is more about court processes and human services, and that is not the committee's usual wheelhouse. That means there's a lot more legwork required to familiarize lawmakers with the bill and to make the case for why it's important to move it forward when it's competing for time with stuff that's much more related to the infrastructure questions they're usually dealing with. Rep. Peterson has been a really great champion, and we have great partners in this. We have the National Vehicle Residency Collective, who's done amazing work with us, the Northwest Justice Project, who have represented so many people caught in this situation, the Seattle King County Coalition on Homelessness, who advocate for all unsheltered people, including those who live in vehicles, and even more than that, whose names I'm surely forgetting right now. So we're going to keep working on it. One more exciting piece of news related to this issue, you can see in the picture on the slide. City of Seattle versus Long is not the only major impound case to come out of Seattle in the past few years. In 2018, a woman named Amanda Ogle was living in her car when it was stolen, abandoned, and impounded. And a court ruled that she should get the car back because she hadn't actually broken any parking laws. But Lincoln Towing defied the court, held on to it for months, and charged her ultimately more than $20,000 in fees to get it back. She got help from an attorney with the Northwest Consumer Law Center named Kevin Eggers. And after a long time in the courts, she was able to win her case. And there's now an award-winning film about that case starring, I guess I can say now, Oscar-nominated actress Rose Byrne and Dominic Sessa as Amanda and her lawyer. It's premiering this Friday in Seattle at 7:00 p.m. At that first showing, there's going to be a Q&A afterward with Amanda and Kevin. So if you're interested, we super encourage folks, go and see that. Ask your local theater to schedule showings. I'm probably going to try to do that in Olympia. This is just a great way to show what people in Amanda's situation are facing and just really get into the details of these barriers that most of us don't face and so don't know about. That's all. Happy to take any questions once we're done, and thanks everyone for being here.
Thank you, Sarah. Next slide. So we are opening up for Q&A. You should have a Q&A button at the bottom of your screen. While folks are thinking through potential questions, I just sort of want to call out we are still in legislative session. The governor is still signing bills. There are efforts to make sure that we are that good bills get signed by the governor, that bad bills get vetoed by the governor. This was a difficult session. We are still a bit raw from the difficulty of the sort of deficit framing, cuts, fast sessions that where we lost good bills. And I know other folks on this call, as I see on the participant list, have had similar experiences. So I just want to name that. I think here at CLS, we're going to catch our breath. We're going to recharge, strategize as to what we need to do to push the bills that didn't make it through this year and the bills that we didn't even put forward this year as to what is the plan moving forward for next session. And with a legislature that's going to look different as it always looks after an election season. We had three retirements we had with including Senator Saldana, Senator Conway retired, Senator Warnick retired. We're going to have some changes in both the upper and lower chamber, and need to develop relationships with the new folks who come in either from the House or completely new members of the legislature. I also want to say thank you so much to all the coalition partners who we were fortunate enough to work alongside on all of our proposals. No good bill passes with just one group pushing it. No bad bill gets stopped. It is a team effort. And thank you all for the work that you did and for partnering with us on at least getting what we could across and stopping the bad stuff that was out there. So having said that, I am going to now. Oh, I see. One question in the Q&A, and then I see. Okay. Do you have any thoughts on changes coming to our Supreme Court and how that might impact current legislation and challenges we might? It feels tough to predict, but our Supreme Court will look very different. I have thoughts. Does anybody else on the panel have thoughts as well? We've had a very, at least at limited level, we obviously the Supreme Court has been friendly on a number of issues, and we feel like it. Trying to figure out how to politically say it may get friendlier. Considering some of the retirements, so in terms of at least more connected to the issues that we are thinking about and how we look at our advocacy and some of the systemic challenges that the communities we serve face. So I'm feeling positive. Is any panelists feeling different? Head nods, head shakes, head shakes. Andrea?
No, not feeling different, but we do have two Supreme Court seats that are up for election. And that's because those justices decided to serve out their entire terms and not give an opportunity for the governor to appoint anyone. And so I hope for good outcomes for our clients in those races as well. But in an election, all sorts of strange things can happen and have happened in past Supreme Court races, essentially based on people's names and nothing more. So we hope that that won't happen again. And we encourage folks to get educated about the Supreme Court candidates and tell their friends who they support.
Thanks, Andrea. I saw a chat from one of our colleagues that didn't, I don't think it came through the regular Q&A, but there it is.
Moved
Got
into
it.
the Q&A.
How many years until the state budget issues will be resolved? That is a great question because it has felt it's been 3 years of budget posturing, a deficit posture. It was 3 years ago. It was Inslee's last budget. I'm sorry if I have a year off. Please forgive me. I'm not great with it. It was there were such budget cuts that I do remember that the Department of Corrections had even pushed a bill that was promoted good time and earned time as a budget saving mechanism that Governor Inslee supported. And then all of a sudden, there was an influx enough or a change in the forecast that it wasn't as dire of a picture. Um, but it has been, and DOC dropped that bill, which is still is frustrating because it was good policy and it also saved money. But regardless, it has felt like the message has been that there have been programs put in place with such a heavy bow wave, like that become more and more expensive over time, that we will continue to have deficit challenges in years to come. That the 4-year picture is problematic. There were very problematic cuts this year, um, and there is no revenue coming to save the day right away until the millionaire tax goes through, the likely, you know, um, election challenge, the challenges in courts and goes through that process. We may not see any income from the millionaire tax for several years. So I still feel like there isn't a rosy picture of a budget where um, there is an opening to do a lot of good stuff. But I do feel that a number of advocates and advocacy groups did hold back. And I don't think that that's a permanent place that we're going to be. I think there's going to be push for new programs because they are the right thing to do. So again, we're still sort of dealing with the aftershock of this particular session and need to think through the strategy moving forward. But thank you for that question. Um, Is there any thought towards rolling similar protections for immigrant vehicles that have been involuntary abandoned due to ICE detentions? I don't remember that coming up in this legislative session, and obviously that's been in the news in other circumstances. But I will say that the legislature writ large this session was very much um, concerned about ICE overreach. So we very much supported the anti-masking bill that went through, and the Immigrant Worker Protection Act is there as well. There were some bills that we would have liked to have seen make it through, like creating a situation where to give individuals the right to sue ICE officials if they violated someone's constitutional rights. That did not make it through. Obviously, the detention bill that we liked that would have required critical incident reporting didn't pass. Goodness, there was a bill that would have this wasn't on our sheet of things that we worked on, but there was a bill that attempted to divest state investments from private prison companies. If you know what get credits are, if you know anytime that the state is investing in funds for pension reasons, for raising revenue that way, um, the state actually invests in private prison companies like the Geo Corporation. It just feels awful. And that bill was presented by Senator Trudeau. That did not move this year. So there was a lot of activity. There was a bill trying to put together a B&O tax on private detention facilities as well that didn't move. A lot of action around trying to rein in ICE and federal overreach, but not all of the ones that we would have liked to see would have passed. Did pass, and we would have obviously liked to see a bill like the one that the commenter raised related to abandoned vehicles. That should have been proposed as well, and maybe we'll see it next session. Sarah, did
Can
you
I
see
add
something?
something?
Yeah.
Yeah, I just wanted to say if you want to chat about this at some point, Rachel, I would be interested to know, yeah, about the specifics of this issue. There is some stuff in the bill around stronger protections for abandoned vehicles because people who live in their vehicles if they're not in great shape or if they're parked in certain places, often get classified as abandoned as a way to get rid of them more quickly when they are very much not abandoned or even operational. Anyway, there may be some overlap in issues here, and I would be interested to know if the current bill would help with that, or if, there's other aspects to the issue that we should be thinking about for the future. So I would love to chat with you about that.
I'm looking at the Q&A. I do not see any other open questions. So with that, thank you all so much for joining this legislative lunch and learn. Please do reach out if you have other questions. We're happy to talk about this as we geared up for 2027. And thank you again, all of you who worked on this issue and all of our partners. We really appreciate you.
Antonio, there's
Yes.
a quick question in the
Oh,
Q&A now, I think, just asking when the masked agents bill takes effect.
oh goodness, I have not seen the effective date, and I don't know if they made it immediate or not. How about this? My email, antonio.ginata at columbialegal.org. I will find it and I will tell you.
Alicia seems to know. So,
Great. Excellent. Someone pipe up because I can't open up my screen right now. I don't want to crash my system.
Alicia, did you say you wanted to? Yeah.
Oh no, I do not know the answer to this question. Please email Antonio. I was just
Okay.
clicking through the questions.
So the way it works, however, is that the bill language will specify an emergency if they want it to take effect immediately, or it'll be standard July 1st of the year that it passes, if that was not the case.
Takes effect immediately.
There you go. Emergency. I'm not surprised.
Nice
Thank you,
work.
Sarah. There you go. You see team effort here at CLS. All right. I'm not missing anything.
There's one more asking
Oh,
whether the bill
goodness.
will be challenged.
Um, yes, I expect it will be challenged. How about that? From what I saw, law enforcement put up concerns about. They didn't like the bill, so I wouldn't be surprised if it was challenged. Okay. You may have 15 minutes back to eat the rest of your lunch. Thanks, everybody. Good to see you.